Hi, my name is Lisa Cummings. I am an attorney with the law firm of Cummings and Cummings, and today I'm going to discuss the topic of qualified domestic relations orders and what happens when there are QDROs following the divorce. Just a moment about our Cummings and Cummings law firm. We are a full service law firm. We support both corporations, small businesses, partnerships, as well as individuals. We support individuals with their estate planning, with their retirement planning, as well as provide support regarding their retirement plans. And now a little bit about me. As I mentioned, my name is Lisa Cummings. I am an attorney, and I have spent my career working with corporations as well as individuals who work at those corporations understand their compensation and specifically their benefits, their retirement benefits more clearly. Now let's get to a refresher on what exactly is a qualified domestic relations order. A qualified domestic relations order is a legal order that is used to divide the retirement benefits in the event of a divorce. The individual who owned the retirement account to begin with is called the participant. And in a divorce situation, the individual spouse to whom a portion of that retirement account is being awarded is called the alternate payee. So in this presentation, I'll be talking about the participant, the original owner of the retirement account, and the alternate payee. That would be the spouse who is supposed to be receiving a portion of the retirement account set out in the divorce decree. Remember, a divorce decree alone is not sufficient to be able to get those retirement account funds to the alternate payee. A QDRO is required in order to avoid early withdrawal penalties and tax issues to the participant, as well as a QDRO has to be signed by the court and submitted to the retirement plan before that retirement plan can take the participant's account and award a part of that to the alternate payee. So what happens if you don't file a QDRO when the divorce decree is finalized? What happens now? When couples divorce, they sometimes or often assume that they don't have to file a separate order that's called a QDRO to divide the retirement accounts. However, failure to file a QDRO immediately following the divorce can cause irreversible financial harm. Without a QDRO, the alternate payee may lose access to the benefits awarded in the divorce decree, or the participant may face unintended consequences of a tax nature. So let's dive a little bit deeper into these possible negative outcomes. Let's talk about risk of failing to obtain that QDRO as it relates to losing access to the account itself. If the separate federally required QDRO is not filed, the alternate payee is awarded a portion of the retirement account in the decree. However, that alternate payee could risk losing all the benefit together because that second document, the QDRO, is not filed with the court and is not provided to the retirement plan. If the retirement plan administrator does not receive that court-approved QDRO, they cannot legally award a portion of the participant's account to the alternate payee. In the meantime, if the participant retires, withdraws funds, or passes away before the QDRO is approved and submitted to the retirement plan, the alternate payee's ability to receive payment may be lost forever. Think about this. If that QDRO hasn't been filed and the participant remarries and passes away, the participant's new spouse could receive the retirement account instead of the alternate payee as was intended by the divorce decree. So let's think about this in a different aspect. If a QDRO isn't filed, and let's say the participant, the one who owned the account in the first place, wants to help the alternate payee and attempts to withdraw his or her retirement account and give a portion of those funds to the alternate payee, the participant could end up paying income taxes and potentially additional tax penalties for early withdrawal. If instead the QDRO is correctly approved, drafted by the court, approves, and then split, the transfer to the alternate payee is treated as a direct allocation to the alternate payee. The alternate payee may then roll over funds to an IRA, or they may request payment. And when the alternate payee requests payment, the alternate payee will be the one who has responsibility for paying the income tax due. It should be noted the alternate payee does not have to pay the additional tax penalty for early withdrawal. If the retirement plan administrator does not receive a court-approved QDRO, they cannot legally award a portion of the participant's account to the alternate payee. So, failure to obtain the QDRO immediately after the divorce can also cause other problems. For instance, if years pass after that divorce decree is filed, but before the QDRO is completed, several difficult situations can occur, and that would sometimes prevent the alternate payee from ever receiving their portion of the retirement account. One example would be if the retirement plan of the participant merges with another retirement plan. When the employer sells their business to another company, the new retirement plan may not be able to be located. Another example is if the participant has already left their job and withdrawn the retirement account when the QDRO is filed, then the QDRO will not be able to produce any funds for the alternate payee to receive any payout. Another sad example is if the participant passes away before the QDRO is filed, then that retirement account may be allocated to the participant's estate or his or her current beneficiaries. Returning to court years after the divorce was granted can be expensive, and unfortunately, the retirement account may have already been depleted. So, what to think about now? Some really good next steps are to think about the fact that both parties to the divorce, both the participant or the owner of the retirement plan account, as well as the alternate payee, should ensure that a QDRO is completed and filed. And then that decree, the QDRO itself, has to get to the retirement plan administrator. So the QDRO has to first be signed by the court, and then that signed court order needs to be submitted to the retirement plan administrator. Now, if the participant, the original owner of the retirement account, does not file the QDRO, the alternate payee should seek legal counsel who is knowledgeable about retirement plans and ask that legal QDRO consultant to prepare a valid document, which in turn can be filed with the divorce court. Acting promptly to file a complete QDRO with the divorce court and then submitting the order to the retirement plan can help protect both the plan participant as well as the alternate payee by preventing loss of financial benefits, avoiding unnecessary tax liability, and securing long-term financial stability. To request a free ebook, you can go to our website, QDRO.law, that's QDRO.law, or feel free to send me an email. My email address is on the screen, lisa@cummings.law. Thank you for joining us today, and I wish you a great afternoon.